Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, and holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for a
Hello, everybody. Sorry, I'm just trying to catch up on chat a little bit. I don't think I'm going to be able to scroll all the way to the back. Oh, Sashina, that's so sweet. 14 months. Love that. Hi, Sarah. Bill's here. Cellulite Yoga Pants, Miss Vicky, Sean, Naybell. Positive vibes for anyone who needs them. I love that. News now. What's going on? It's Friday night, people. I hope that everybody is good today. Well, if you can make it happen. And I have some court for us to watch. Woo! MB, thank you for your comment on last night's stream. And Vicky, that was an interesting case yesterday. Hey, Lindsay from North Carolina. Hey, y'all, she says. I love it. It's chilly today here on Vancouver Island. On my little island in the Pacific, it's a cold day. But I'm feeling pretty good, and I'm ready to share with you a few different things. But before I share with you, I would like you to share with me what you had for dinner. And if you didn't like what you had for dinner, tell me what you wish you had for dinner. It's cathartic sometimes. I had homemade soup for dinner. It was delicious. I feel overly full. That might be the cookies. I also had homemade cookies. I live with a private chef. Don't forget. She's fucking awesome. I will say that. Burnt grilled cheese, wahoo! Pizza and wings, spaghetti and meatballs. Sashina wanted smoked salmon. I get that. Cheeseburger for Vicky. Grilled chicken, broccoli, and cheese noodles and corn. White chicken chili. That sounds pretty good. The soup that I made, I cooked the chicken. It was a whole chicken, and I cooked it in my Instant Pot slow cooker on the slow cooker setting for like 20 hours. And then what the fuck was that? I cheeseclothed the bowl, poured it in there, then I made soup. Oh, and out of the broth. How good is that? Extra good. I usually refer to that as stealing the soul of a whole chicken. Oh, MB, was that you? Is that what that sound was? You're so sweet. I love you. A PP from MB. Three of my favorite initials. PP and MB. Thank you so much for the PP. I love you too. Yay! Wait, I can hit thank you. Thank you, PP. Seriously, thank you so much. That is so sweet. I really appreciate that. Okay. I also made enchiladas last night. We saw them before they went in. They were delicious. Turned out perfect. Yum. Again, living with a private chef has been the best part of my 30s. Becoming a good cook. I'll say that. But it's taken a lot of work, especially many hard hours. of Food Network. A lot of Food Network. Anyways, as always, let's watch some court. Thanks to Miss Lucy for the tip on this one, as usual. A tip about these things is really handy. I'm terrible at all different types of checking shit. But sometimes it gets through, and then here I am. So, where did I put that? It was a download, right? Yeah, that's right. It's a download. So, we're off to McNabb's court. This case is interesting. Hi, Miss Courtney. Hi, Over It. Hi, Beverly. Erica's here. Your husband's a really great cook, and you're a food snob? Oh, that's funny. I am not a food snob, but I enjoy it more and more as I get older, and I'm more and more confident in my own skills as I get older to try things. But one thing I'm glad I'm not about to try is getting divorced like these people. Let's watch it. Okay, bad transition. Try harder next time, please.
Good morning. This is the matter of Martinek versus McFarland, case number 2402644DO. Present in the virtual courtroom, we have Attorney Amber Solar here for the plaintiff and Attorney Robert Zeta on behalf of the defendant. We are here on the plaintiff's motion to compel discovery. And I have read the motion. Ms. Solar, do you have anything else you'd like to say about it?
I do, Your Honor, and I'll be brief. First, there was some additional, after the motion was filed, there was some additional production of some statements as well as a supplement to the request to produce. So largely the remaining issues are going to be with the interrogatories themselves and the request for the defendant medical records related to the Kent County Health Department. Speaking first to the interrogatories, there were.
So, this is the key factor about this case. So I think it's the gentleman in the middle and the gentleman in the top that were married. And they are, hi, Lucy, and they are getting a divorce. And for some reason, there's a motion to compel about public health records? Or is that what I'm to understand here? So, well, hi, Chuck. Hope you're well. That's what I'm gathering thus far. Oh, that says no recording. Are you going to tell on me? Oh, you're such an asshole. You're so rude. Hi, Mikey. How are you today? How is your thumbnail game? On point? Anyways, this is serious. This is a serious matter. I am the one recording it so that people can see it later. The judge has already deleted it, so thank you to Lucy for telling me about it. When she messaged me, I literally ran. I was like, oh, okay, I'll go right now. By the way, go ahead and hit the like button. Yes, it's two husbands getting divorced, and the bald husband, okay, so the guy on the bottom, I mean the guy on the bottom row is asking for the top guys, top row, his sexual partners. Anyways, let's continue.
Was a request number 3 of the interrogatories regarding identifying sexual partners. That was objected to by the defendant, claiming privilege. We do not believe that there's any privilege from that. There is a
ouch. First of all, if somebody was like, there was no privilege in being your sexual partner, I would be hurt. But secondly, uh oh. Uh-oh. That's what I gotta say about that. That is terrible. Why did they need to drag this out in the divorce? Are they looking for at fault here? I thought this was Michigan, where very rarely do we hear of an at fault marriage. They don't really determine that, do they? Maybe I'm not paying enough attention. Or maybe I'm paying too much attention. Maybe someone gave someone something naughty. I think you're getting close there, Cellulite Yoga Pants. Allegedly. All alleged. And Tyler, who's got his sign up, pay no attention to me. I'm Canadian. Don't worry about it.
A false claim that has been made by the plaintiff. That was just very recently, the defendant took a position that my client was living a similar lifestyle to the defendant, which is frankly untrue. But in order to be able to properly defend against those reciprocatory claims, we do need the answers to these interrogatories, and we do need the health information that was requested as well. Since we are live and on the record, I'd prefer to not speak openly about what specific records are being requested, but it was laid out in the motion.
And I did read it, so there's no need to do that.
Thank you. We're happy to enter into a protective order for those records. We have no objections to that, but we do believe the records are needed as to speak to fault in the upcoming trial that is scheduled for just a few weeks away at this point. We would request, Your Honor, that a couple of things. First, while the documents, as far as statements, were produced, we would ask that the court order an ongoing obligation to the defendant to continue to supplement those responses should any additional statements be found to be missing or any account information was not provided. We would also request that interrogatory number 3 regarding partners be answered in full. Finally, we would request that as to the health records, that either the court order the defendant to sign a waiver that has been provided to him for the Kent County health records, or in the alternative, that the court order the Kent County Health Department to provide those records to plaintiff.
Oh, NPC, hi! Thank you so much. You're so sweet. And Chuck raises a good point. It's not quite, but it feels like it. Andrew fits Robert and Robert fits Andrew. What would the odds be in a couple like that? Anyways. Okay, let's keep going.
Finally, Your Honor, throughout this case, defendant has failed to timely produce the records and made these new claims sort of at the last minute, which has really put the plaintiff at a severe disadvantage while prepping for the upcoming trial. Ms. Large did attempt to reach out to defendant's counsel prior to filing this motion to compel in an attempt to remedy the failures to properly answer, but was not given a response. Plaintiff supplements were only made by defendant over the last few days, and only in part. And that was made because of, sort of last minute. Again, it's having an effect on plaintiff's ability to be able to properly prepare himself for the upcoming trial. Because of this, plaintiff is asking for attorney fees and costs as they relate to this motion as well.
Mr. Zutta?
Thank you, Your Honor. First of all, I am covering this hearing for my partner, Michael Zeta, who's the attorney of record.
Is he your brother or your father or your son? Or I guess your like nephew or your niece. I mean, who am I to say that it couldn't be his niece or his husband? Oh my God, MB, I'm so rude. Oh, his husband, of course. uh, maybe he's running a gay attorney racket, allegedly, in Michigan. I don't even know what that would be. Just like dealing with all the gay stuff that happens. Not that there's anything bad about it. I just mean like there's always niches that lawyers create for themselves. It's entirely possible that that is a total niche. Allegedly.
For Mr. McFarlane. With regard to this motion, it's my understanding then that the three issues are remaining. That's requests 3, 4, and 5 as contained in the motion. The other matters have been resolved, according to my understanding, because of work that has happened since the motion's been filed.
All right,
So-
I'm going to stop you a moment just to confirm with Ms. Solar. Is that an accurate statement?
That is, Your Honor.
Okay.
As I stated, those have been complied with at this point.
That's what I thought, but I just wanted to remove any doubt from the record. All right, Mr. Zeta.
Thank you, Your Honor. The first item to be addressed then is request 3, which is to identify all sexual partners you have had during the marriage by name and city, state, or county.
Now, just that could get messy. Could you imagine if, you and your partner had a healthy sex life for a while and that included other people? It would be pretty hard to name everybody for some people, I might imagine. Allegedly. Supposedly. I think somebody's trying to air out the dirty laundry.
We have asserted privilege as one basis to deny that. Secondly, it was asserted that discovery wasn't reasonably calculated to lead to admissible evidence, but really was designed to harass the defendant more than produce necessary discovery. It's the argument of defendants that any person involved in an encounter like this would have a reasonable expectation of privacy, and knowing their name or a person's name, again, doesn't seem to be required. It was admitted that these encounters took place, as my understanding in terms of discovery, and really this could have been asked differently if the object is to determine how many encounters, then that could have been asked, but that wasn't the question. It's to identify persons rather than numbers. So that's our argument on that request. On request 4 and request 5, again, privilege was asserted, and the privilege that was asserted was doctor-patient or physician-patient privilege, which is MCL 621-57. This isn't just something that can be invoked by a doctor. It's something that can be invoked by the defendant, as he has done in this case. He has a privilege with regard to medical information, and we would ask that the court protect that privilege by virtue of its ruling.
Are they both not on PrEP or whatever the other name is for the... Like, here's why I ask. If you go on a HIV preventative medicine, you're actually monitored very closely in terms of STDs. They check people in order to give them the medication. So, and it's a pretty common thing these days for... I know that there are lots of other STDs. What I'm saying is that early detection is sort of key in a lot of those, and it would be pretty easy to narrow down the time frame if they were on something like that, because they would be having like every 2 to 3 months blood work and STD test done in order to continue taking that HIV preventative medicine. I don't know. That's at least how it works in Canada, as far as I'm aware. They're pretty strict about it.
Again, at this point, the items that are sought are health records. There's nothing else in 4 and 5 other than health items. As to attorney fees and costs, Your Honor, defendant has been, first of all, asserted his responses to those requests in good faith, where he believed that privilege was in fact involved. And subsequently, once this motion was filed, again, has been working in good faith to trim the issues down to where they are this morning. So we would ask that the court deny the request for attorney fees and costs and deny the requests 3, 4, and 5 that are advanced in the motion. Thank you.
Thank you. Ms. Solar, I guess the question the court has at this point is, why do you need the names if there's an admission that there have been multiple affairs?
Well, Your Honor, I think more so than the names, if the court is unwilling to allow the names, we would need at a minimum the number, and we would like some location information as well. It goes to the.
Why do you need to know which park or parking lot it occurred in? Seriously? Come on now. Why you gotta ruin everybody's fun? He already admitted. Get over it. There is really no sense in dwelling on the past and who came where or on who or what. So just move on, ma'am. Move on.
The veracity of plaintiff's claims that there was a lot of unknowns happening during the marriage, more affairs than what has even been disclosed at this point, and a lot of what, frankly, we believe is very reckless behavior that has put my client at risk and contributes to the question of fault in this matter.
All right. Any other rebuttal you'd like to make?
No, Your Honor, I will rely further argument on what was placed in the motion itself.
All right. The court finds that the interrogatories requested are reasonable, material, relevant, but I will, and so the court will grant the motion subject to a protective order as far as the health information is concerned, or that the defendant sign a waiver for those particular health records so that they can be released to the attorney in this matter. That question 3 be limited to numbers and locations rather than specific names, although the court would be willing to revisit that if something changes in terms of why that might be relevant. But at this point, I don't see that it's relevant on the actual names since there's been an admission.
It's gonna be really hard to set up the voodoo doll without a smidge of hair and a name, Judge. So that's why we're requesting for the names and the health records for the DNA, just so we can get that voodoo, working. You can see the little shrine behind him there. So he's got lots of shelves to fill here. We're anticipating dozens of names.
As far as attorney fees go, the court will reserve attorney fees so long as there are no further discovery motions that are where the plaintiff prevails in this matter, and remind actually both parties that they have a duty to supplement a discovery pending trial or settlement. Is there anything else that the court needs to address today?
I don't believe so, Your Honor.
Your Honor, just to specify in the order itself as to production, did you want, should I put in the order that defendant will sign the release, or did you want me to put language in that where the court is ordering the health department to?
Sign the release. Health officials have less of a problem when it's the patient who is releasing as opposed to the court ordering it.
And then I will draft the order, Your Honor. Thank you.
All right, thank you. We're adjourned.
Take one down, pass it around. Next McNabb case for us to watch now. Oh, those were cute. What are those little guys? Oh my god, they're so cute. Okay, have a wee intermission to look at that while I find the next thing that we're gonna watch. Are they meerkats? Or is it just my dirty desktop? Just a dirty desktop, Paisley. Who's this? Danielle?
Good morning. This is a matter of Norris versus Norris, case number 24-12716-DM. Both parties are present, representing themselves in the virtual courtroom. We're here on the plaintiff, Ms. Norris's motion for a temporary order. And Ms. Norris, I have read your motion. Is there anything else you'd like to say about your motion?
Yeah, I'm just requesting, as you saw, physical and legal custody of the children. I believe it's in the best interest of our children. Matthew has a history of not having
Oh,
the
what's
best
she gonna
temper,
say?
and I think
Oh,
for
wait,
now
wait,
that
wait,
it would
wait,
be.
wait. I was supposed to pause you. I didn't. But I spoke over you. So I'm going back 10 seconds. What doesn't he have? This is such a hard burden to hit. And Matthew, can you move your thing over the camera? We can't see you.
Not having the best temper, and I think for now that it would be in the best interest of our children. Also to have split time between the two of us, so still having parenting time with their father. But yeah, that's what I'm requesting.
All right. I have a question about your request for sole legal custody. That sole legal custody means that, or
Oh, Matthew. Oh dear. What's happened? Matthew looks like a video game NPC character that works in a funeral home that is part of a GTA mission that you have to like drop something off to. But she picked him. She had multiple children with him. You make your bed, you lay in it, right?
joint legal custody, I should say, means that both parents, the other parent has to be consulted about major life decisions about the child or children. So, for example, choice of school, if, God forbid, there should be, a decision that needs to be made at the hospital, kind of a thing. It's for major life decisions only. And the court doesn't generally award sole legal custody unless it's an extreme circumstance. So,
Okay.
I guess, I would need, in order to do that, even on a temporary basis, I would need to hear more about why he should not be involved in those major decisions.
Okay. As far as the decisions go, I think that he's capable of making that. Is that so? Like, if he has like parenting time with the kids and something happened and they go to the hospital. Okay.
That's part of it, but the biggest part is you would have to consult him and he would have to consult with you about anything major, like a choice of school or something like that.
Okay.
And for example, if you were to take the children out of the country for a vacation or something, you'd need his permission in order to be able to use their passports. It's
Okay.
just like I said, major decisions and things that other parents, unless, there's some unusual circumstance in the case where the other
Mhm.
parent really should know what's going on and have some
Okay.
input.
Yeah,
And
for
then what
sure.
happens is if there's a disagreement and you have joint legal custody, then either one of you can come to court and ask for the court to make the decision. But then you both have input as to what you think the right decision is.
Okay, great.
So is
That's
that
fine.
okay with you? Okay.
Yep.
All right. All right. And Mr. Norris, do you have any objection to what she's asking for?
Good morning, Your Honor. I do. Um, I filed my motion in response
I didn't get it.
yesterday. I filed it with the court.
I didn't get it. It was too late.
I acknowledge that, Your Honor. Okay.
Uh, not a good sign. Not a good sign, my bro. Not a good sign. Also, don't talk over the judge. That's like my thing, and they don't like it. Sorry. Just to let you know.
Okay. If I may, also, Your Honor, I was not in a timely manner, and due to that fact, that's why I did file my response yesterday. I do have a copy of my response in front of me, and I object to the plaintiff's motion for temporary sole physical and legal custody on the grounds that I do believe it is in the best interest of our children for us to have both joint legal and joint physical custody.
Did you not listen? She already agreed. Did he literally just not listen to that? She just agreed to that. So I'm confused.
Thing I would also like to point out, Your Honor, is that line item number 10 in the plaintiff's motion for temporary relief, she states, and I quote, they currently live at my house with me, meaning her as the plaintiff. I'd like to state that that is factually incorrect and that my name is still on the lease. I still hold domicile there. I still reside there during my parenting time.
All right. So you're sharing the house during parenting time? But one
Yes,
of you
ma'am.
leaving and the other one's there during that time? I'm seeing
Yes,
your head
ma'am.
nod. Okay. All right. Do you dispute that she's been a stay-at-home mom?
No, Your Honor, I don't. I would like to assert that the plaintiff has refused to seek gainful employment for some time now.
All right.
And if I may, Your Honor, I'd like to read my response.
No, that is not
it.
appropriate. You've already entered, what your objections are, but at this point, especially this is only a temporary order. What I will do is I will refer this to the front of the court for an investigation. They will contact both of you. They'll contact anybody that you want them to talk with. They'll go through the Michigan child custody factors and make a recommendation to the court after a full investigation. Obviously, a few minutes on a Friday morning is not sufficient for me to make a final decision. So, but given the fact that it's undisputed that Ms. Norris has been a stay-at-home mother through the course of these children's lives, at this point, I believe that joint legal custody should be awarded to the parties, and temporary physical custody should be awarded to Ms. Norris. Again, based on the admission that she's been a stay-at-home mom, that the parenting time that was requested in the motion as a temporary matter is appropriate. Let me say, what is happening now? What parenting time you said you're coming to the house for parenting time?
Yes, Your Honor. And
So
I may, Your
what's your
Honor.
schedule? What's your schedule right now?
My schedule right now, Your Honor, is it's been fairly sporadic with the plaintiff. It's been fairly fluid. We have been going every other weekend and then overnight throughout the week, typically on Wednesdays or Thursdays. But I included with the motion that I filed, a parenting time journal showing all of the overnight stays that I've had with the children.
Okay, I haven't read it.
Um,
Just tell me, okay? What have you been doing? You said every other weekend and one night per week overnight in addition?
Roughly 1 to 2.
Okay. Um, then again, based on what the status quo is, the court finds that the parenting time that has been suggested as a temporary matter is appropriate. So every other weekend and Wednesdays overnight with a pickup time at 5 and a drop off at 5. And again, and I will grant the plaintiff exclusive use of the marital home pending the final outcome of this divorce matter. The front of the court will be contacting you regarding the referral for the investigation. Make sure, first of all, let's see, I'll split the fees between you. There are fees for that investigation, 50/50. And you need to pay those fees or the front of the court will cancel or terminate that investigation. And let's see what else I need to. They'll be contacting you once they receive the referral from the court. Make sure that you watch for that and that you respond to them immediately. All right.
Your Honor, I would like to add in that I am the only one capable of paying the rent and the utilities, groceries, and everything else needed for sustaining life for the children.
Okay, well, the court will enter a
plaintiff-
status quo order. That's typically what we do in these cases. So the finances,
So what that means, sir, is that you have to keep doing that and deal with where you gotta live in the interim. Until. Very, very, you just literally it made it worse. You just made it worse. She probably would have put the status quo order in there anyways, but dang it. And Danielle may need a job, but right now, you gotta maintain the status quo.
will be status quo. Any bills that you're paying, you need to continue to pay on a temporary basis until we get this finalized.
And even though, Your Honor, I am the only one paying for everything, the plaintiff is still allowed to reside in the home, and I'm not.
Yes, because
Am I Okay.
you've admitted she's been a stay-at-home mom, and it's the best interest for the kids right now. Like I said, until we get I get more information, that's what I'm going to do. Okay.
Yes, Your Honor.
Just make sure, like I said, you reply to the front of the court immediately. And if you have questions, I really encourage you to consult with an attorney. Okay.
Yes,
All
Your
right.
Honor.
Thank you. And Ms. Norris, you need to submit an order to the court, temporary order that the court can approve that indicates what I ordered today. We'll take care of the referral to the front of the court, but the actual temporary order you need to fill out and submit.
Okay.
And it looks like you got the motion from the Legal Assistance Center. Is that right?
I did.
Okay. They can give you, if you don't already have it, they can give you the form for the temporary order. Okay.
Oh, also, I was child support and alimony. Is that going to be addressed today?
No, that's being referred
Okay.
to the front of the court. I've also ordered him to pay the bills. So at this point, child support's not appropriate, but it is going to the front of the court for an investigation for future. Okay. Because that's not going to be the situation forever. Okay.
Yeah. Okay.
And more than likely you're going to have to get a job. So you should start looking for one. Okay.
I graduate in February. Thank you.
All right. All right. We're adjourned. Thank you.
Thank you so much.
Thank you, Your Honor.
Oh, Miss Carrie, just for you, guess what? We're having a little bit of an extra long night, so we have something extra special up my sleeve. I thought I did. Where is it? Where is it? There it is. Oh, good, I do. Yay!
First thing we're going to do this morning
Good.
is take roll, find out who's here. So if you're
Before you do, Judge, let's us take roll call for a minute. Mr. Kyle Baxter, ladies and gentlemen, he is very much wearing a Hawaiian shirt over top of what looks to be a black long sleeve shirt and a hat. Bye, Chuck. And then what else do we have here? Vitali, that's an interesting name. And Donna down at the bottom, and also Evan Mapson. Let's see what happens. I don't know if we're actually going to see any of these cases. Hopefully we do. Let me just do a scrubbity-dub-dub-dub. Scrubbity-dub-dub-dub. We do, I think, have like this. I don't really want to listen to him talk about all the same shit all the time. He's always talking about it. So yeah, there they go to the mediator. We'll start from here. Okay.
You could be the, that's one, yep.
Do it all.
No, yeah, actually just get them all to me.
Okay, with only one party present or just one?
No, where there's just one party present.
Okay.
I'm gonna make bread tonight. Oh, I didn't need to pause it. I'm gonna make bread tonight later. Cinnamon buns and bread.
All right, folks, I'm going to run through the calendar for those where there's one party present. And we'll start with the ones where we actually have had service. So Ms. Ingersoll, if you would activate your audio, please.
Okay, I'm here.
Good morning.
Good morning.
Looks like we had service on Mr. Ulrich on the 3rd of December.
Yes,
And you were seeking $1,570.74.
Yes.
As a result of damage to your auto.
yes.
Okay, thank you.
Oh, judge buffering. He's gonna write out these orders.
And I'll just make one last call. Devin Ulrich. Nobody's responding.
She's gonna win, but will she be able to collect it, Miss Carrie? This is the question. There's a really funny folk song called Bald Headed Men by Christine Lavin. Friday dockets? Why are they on in Thornton County? It's not pause. Are you saying Thurston for Monday, or is Thornton a new place that I have to look up right now? Oh, Thurston. Okay. Yes, I track that quite closely. Yeah.
And Ms.
Judge?
Ingersoll, were you charged anything by the person who looks like Randall Makota? For
No,
service?
he's my roommate.
Okay, thank you.
Yeah, they switched something around because of the date. Like, is there a holiday on Monday?
All right, I've granted you judgment for your principal amount in the claim plus the $50 filing fee, total $1,620.74. And you can reach out and get a copy of the judgment from your file in the district court civil office.
Thank you very much.
Yes, thank you, Ms. Ingersoll.
You have to tell them about their crop circle. MB. Oh, a lot going on next week.
Ryan Finn.
Good morning.
Mr. Finn, good morning. Looks like you serve the registered agent for Ascending Asset on the 4th of December. Is that right?
Correct.
Okay. And there is nobody responding from Ascending Assets. Court did not receive anything from them. They still in business? Do you have any idea?
Thank you. You guys are so sweet. I was asked why I got my nails done today, and I said, because I'm a big girl who can get my nails done when I want.
I noticed that their filing is delinquent at the Secretary of State, and I had the Dispute Resolution Center reach out to them, and I don't believe there was a response either.
Okay. And your claim was for $9,511.89 for contract breach.
Correct.
Okay.
That's a big judgment. I don't think I had a vape in my hand. I think I had a lighter. One's a lighter, one's a joint. In my beautiful little hands. This person's about to get an almost $10,000 default. But you know what? This is the... Oh. Don't. You know what's the crazy thing, though? If you don't... It's really hard to execute getting money back from people, especially if a company is sort of dissolved. It's a whole industry. A whole...
Yeah, it looks like your service fee was $85.
Yes.
So funny enough, Carol, I checked out the price of these today and converted it to American dollars for my curiosity. And they were 45 American dollars, including a tip.
All right. Total judgment, $9,646.89, giving you the filing fee and service fee.
Thank you, Your Honor.
All right, Mr. Finn, and that order's been signed and is available to you through the civil office.
All right, thank you.
Thank you. Have a good day.
You too.
And Michael Maurice.
Yes, thank you.
Hi, Hector.
Morning.
And you're seeking $1,870.06 for rental car reimbursement while your car damaged in an accident was being repaired.
That's correct.
Okay. And Mr. Hendrickson was the one who damaged your vehicle.
That's correct.
And for the record, I see service on Mr. Hendrickson on the 26th of November.
That is correct, yes.
Isn't the rental usually included in your insurance?
And was there a cost to the service?
It was 155.
Expensive insurance. Insurance around here is only sold by one person, and that's called the government. And so, like, auto shops provide loaner cars a lot of the time. That's sort of like a feature that they have. Hi, Carla. Um, because, like, you can pick where you take your car to if you've got an ICBC accident. And then if it's an ICBC approved place, they can sort of bill directly to ICBC, which is the Insurance Corporation of British Columbia. Right, Judge? Just down the road from them. Totally different system, though.
With filing fee and service fee, total judgment, $1,975.06.
Thank you.
All righty, thank you very much.
You're welcome very much, Judge. Who's next? Come on, give us a case. Are Marianne and Jamie against each other? Come on now. Judge, you're so serious.
Correct, that is $2,075.06.
So you guys, I literally...
Okay, Marianne
Hey, Judge,
Tyler.
I'm telling a story first. I literally came to the end of an eyeliner today. I've never had it happen. I sharpened it. I went to sharpen it again. And I looked in and there was nothing in the wee end. And to be fair, it was just a wee end. Just a wee bit. But still, I was so sad. So sad. Oh.
Yes, Judge Buckley.
Good morning.
Good morning.
And Ms. Tyler, it looks like there was not a service on Progressive.
There was on November 14. Their agent signed for it at a facility, and I included that in materials to the court on page 11.
I didn't see anything, so let me check.
Well, he checks that. Did we see Ice-T's body cam against the cops? It's bad for him. No, I did not. Auto insurance is insanely high because you've been a crap driver. Really, MB? I am a good driver, knock on wood, because I don't know why, but I am. I pay a lot of attention
Okay.
while driving.
I missed that. Thank you for pointing that out.
Of course.
We had a juicy divorce case yesterday. Was it that yesterday? It was a unique case yesterday. Maybe the day before was the divorce. Brooklyn, tonight we're not doing another divorce, but we will be probably next week. I made homemade soup today from homemade stock. And homemade cookies, and I'm gonna make homemade cinnamon buns. And I just have been neglecting finding new divorces. That's just the honest to God truth. When do they go back? I can't remember. Oh, I might have written it down.
All right.
Oh, Judge, hold on.
Ms. Tyler, I'll sign the judgment just because Progressive hasn't made an appearance today. I'll point out a couple things. One, service probably should have been on their registered agent in the state of Washington through the Secretary of State's office. And they may raise that down the road when they see a judgment entered against them. And number two, there is a legal issue in your claim, but I'm not going to make the case for Progressive, which is they're probably not the appropriate party for you to sue since they're not your insurance company. They're the other person's insurance company. Am I correct about that?
That is correct.
Yeah. So you typically can't sue somebody else's insurance company because they didn't pay the claim. You sue that person is typically what happens, and not the insurance company because you don't have what's called privity of contract with them. They have no contractual obligation to you. So I say all this just by way of sort of giving you a heads up that you're quite likely going to be back before the court on this, with Progressive saying, number one, we weren't served properly, and number two, there's no basis for Ms. Tyler's action against us. So they're not here to make their claim themselves, so I'm not going to make it for them. I'm just letting you know that that's a strong possibility.
I appreciate that. And I did let them know, because I did try to work this out with them. They were processing the claim. And I did let them know I was going to pursue it and ask them to whom to address it and use the address. They didn't give me a name. So it would be looking that up with the Secretary of State if this comes back then? The
Yes, they,
okay.
yeah, they have registered agents there, and you know,
Okay.
that's typically the way folks get service, particularly on out-of-state companies.
I appreciate that. Thank you so much.
Yep. And in your case, the amount claimed was $1,500.
Yes, sir.
Okay. I suspect this will get their attention.
Well, one hopes.
And we're talking about Progressive Insurance, correct? Not
That is
Progressive
correct.
Claims. Okay.
Well, he means once they get their attention, this is not gonna fly, ma'am. Although with the service issue, like, is this just a technicality she's getting around, or is it
And what did it cost you to
Judge!
send that certified mail?
Nominal, $5.58.
Thank you.
Mm-hmm.
Who the fuck is serving somebody for $5.58? In this financial climate? Is that
Total
postage?
judgment, $1,555.58. All right. Thank you, Ms. Tyler. Maybe I'll see you in the future.
I'm not sure how to respond to that. Thank you.
Yeah. You could say, no way, I don't want to see you again. All right, thank you. And Jamie Matthias.
Yes, Your Honor.
Ms. Matthias, good morning.
Good morning.
And I don't see that we have service on Wemberley.
Hold on. Wemberley. First of all, Wemberley. Second of all, wow, what was that? That was so awkward. Awkward. So awkward. My God. Perhaps I'll see you soon. Well, I don't know what to say to that. When you don't know what to say, you don't say, I don't know what to say. Pro tip. That's what you do. Okay, bye-bye. There. Like, seriously. It's so simple.
He did receive it, and he did pay a portion of it. And he has made, good faith efforts to pay off the rest. So I was kind of hoping for maybe like a continuance. So I can he said that he was going to pay the rest last night, and he did not. He paid $1,600 towards the $2,800 so far. So $1,200 is due. He texted me last night and said that he had a family emergency. I was hoping to just cancel it, but now I feel like maybe I should see if I can continue it, and hopefully I'll get the remainder from him.
Okay. So what we'll do is we will reset it. Did she contact you, or do we give her a date?
Oh, we can give her a date right now.
Okay, what's that date?
It would be March 20th.
Okay, the next available date is the 28th of March.
Perfect.
And does she get the notice from us, or
she'll need to reach out to her office.
Okay, so contact the civil office, and you'll need to get Wemberley served another time with the new date. And make sure, at this point, I don't have anything in the file which shows service, so we need to get what's called the return of service filled out.
Yeah.
In order for us to, you can tell me that he's been served and he can acknowledge it, but we need the document that says, yes, he was served. So whoever you have serve it next time, make sure they file a return of service with the court.
Yes, Your Honor.
Okay, so just reach out to civil office and they'll give you the notification for the 28th of March.
Perfect. Thank you.
Thank you, Ms. Mathias. Yep. Bye-bye.
3 days after my birthday, March 28th. Oh, I'm really sorry to hear that,
Okay.
Lucy. You're not getting divorced, but you're going through a breakup. That's really tough. We are
something on
always here
the other
for
three.
you.
Okay, I can do that.
Thanks, Chase.
Filming everything is a good idea, allegedly. This is not legal advice. Was that the end of that? They had no cases today. Do you know what that means? They literally had no cases where both people showed up during small claims court. Damn. Forgot to turn that off. But thank you guys. That's a thank you for everybody else. You, and especially you. I am thankful for each and every one of you. And I'm so thankful that tomorrow morning we are going to do a morning stream. That's right, a morning stream. Love this channel. I love this channel. Please provide me with lonks. I'm joking, and I love you all so much. That reminded me, I gotta write down lonks so that I can change the thing to lonks. It will be prior to, it will begin prior to, it'll begin approximately 10 a.m. Pacific time. Yeah, we could do that. 10 a.m. Pacific. So that is 10, 11, 12, 1 p.m. Eastern. You have a brunch date. I'll bring the cinnamon buns and the coffee. And you guys bring the teleporting materials. And it'll be a picnic party. Yay! Okay. I love you guys so much. Remember that. Do me a favor. Remember, I love you and I'm proud of you. And I will see you in the next video. Okay, bye.
Ways down and ready to